This hearing is now back in session. Over the break, Mr. Lockridge, we found the National Transportation Safety Board transcript of the recorded meeting that you had with Mr. Rush on January 19th, 2018. We're going to enter that transcript as a exhibit, and then but we're in the process of doing that.
Thank you.
So why don't we continue with the line of questioning we were on about when we stopped, and then as we progress, if later in your testimony you'd like to refer back to that meeting, we will now be able to do that.
Understood. Thank you.
Yes, sir. So, Mr. Lockridge, when we left off, you were discussing a settlement agreement, and we can proceed with that discussion, sir.
Okay, so on March...
I'm sorry, Mr. Lockridge,
yes.
I apologize. I do have one order of business before we start again. I just want to make it clear to the record that the counsel for OceanGate at the time of your interaction was not the counsel that is representing them here today. Thank you. Please proceed, sir.
Okay, so March the 16th, 2018, we were basically sent by OceanGate a settlement and release agreement that was sent to myself and my wife Carol, and a copy was sent to OSHA. During that, they wanted me to pay approximately $10,000 because they had to get legal involved to correspond with OSHA, and in that, if I agreed to pay this $10,000, which I certainly was never going to do, then what they state was if I paid it, they wouldn't contact previous employers, previous spouses, cause me fraud, immigration, basically everything that's out there, public knowledge. So we declined. I spoke to OSHA about it. I sent everything to OSHA. It was important that they had all correspondence of the documents. And OSHA's response to this on March the 16th from my caseworker, Paul McDevitt, Mr. Lockridge, and I will reference the email. Another one of my cases, this is called a SLAP lawsuit. Read more about it here by clicking this link. The state of Washington has an anti-SLAP suit law, but in 2015 it was ruled unconstitutional by the Washington State Supreme Court. You might want to consult an attorney. I will ask our lawyers about this as well. I think OceanGate may be using this to pressure you into settling your OSHA complaint. The lawyer representing OceanGate specifically asked me if you were interested in alternate dispute resolution. I know this must be distressing, especially as you're going through the pain of losing your father. Try not to think about this until you get back to the US. I will let you know if I hear any more from OceanGate's attorney or OSHA's lawyers. Never once got any correspondence from OSHA's lawyers. At that point, I spoke to Paul on the phone and I said, absolutely no way I want to proceed with this OSHA claim. It's public safety. So from there...
Sir?
Yes, sir.
Before we progress,
of course,
I'd like to understand the basis for OceanGate's countersuit against you. What was the allegation that you had done?
So the further down the line was wanted me, it was basically a settlement agreement. They wanted me to walk away by issuing all these threats against me. It wasn't, at that point, it wasn't a lawsuit. They threatened in this that they would proceed with legal, sorry, is that me? That they would basically sue my wife and I if I didn't pay this, so I refused.
Understand, sir. Thank you for that clarification. But
Yes.
What was their basis what was the allegation that you had violated?
So they stated that my whistleblower claim under the Seamen's Protection Act was not valid.
Because you would release proprietary information? Was that the allegation?
Potentially. Potentially. I don't know. From a legal point of view, I'm not an attorney. but there's no way I was walking away from this. The OSHA had already done my intake interview for Whistleblower Protection Scheme. Whistleblower Protection Scheme protects people that are in employment and have been laid off because of protection.
Release any information to any other agencies or any other media beyond OSHA?
Media, no. And other agencies, no.
So the only entity you had released any records to
Yep.
was OSHA?
Correct.
Thank you. Please proceed, sir.
No problem. So I refused to pay this. I spoke to my caseworker when we got back, and then I received the email correspondence on March the 19th from my caseworker, Mr. Lockridge. I would like to discuss the possibility of amending your complaint after you return to the US. There is no rush to amend it, and I don't want to make matters worse for you. Give me a call later in the week and we can discuss. I did call him later in the week. I didn't understand why OSHA are asking me to change my complaint. I already submitted the complaint. They were happy with the complaint. They took all my points about the potential risk of the submersible actually coming into action. They took me seriously, as did Labour and Industries when I was first terminated from my project. So that didn't make sense to me. I reply on April 22nd as well, an email confirmation. Afternoon, Paul. As you can imagine, it's been a very stressful time for my wife and I over the last 5 weeks since receiving the threatening 41-page letter from OceanGate's attorneys. Yeah. And I say, I mean, it's a big long email. I'm truly at a loss and wondered if OSHA had any guidance that they could give and what sort of support is available. Basically, I was looking for advice. I was wrongfully under the assumption that I was going to be protected, which had been told to me initially when I spoke to them, by disclosing all this information so that they could actively investigate OceanGate, and to be threatened with the immigration, the fraud, all that sort of stuff. It just didn't make sense to me at the time. As I say, I'm no attorney, but anyway. 23rd of April. Mr. Lockridge, I can well imagine the stress you've been under. I'm glad you've retained an attorney. I had to get an attorney because OSHA weren't helping me. This was another one which was totally out of the blue, and my caseworker knew that I wasn't walking away from this. Okay, this is the OSHA caseworker. Please let me know if you want to take advantage of OSHA's alternative dispute resolution. It's an ADR process. I would think this would be the quickest way to resolve this dispute with OceanGate. Now that you are represented by an attorney, you are on an equal footing with OceanGate. Talk to your attorney, and if he is in agreement, please send in the ADR form, and I will contact OceanGate's attorney to get the process going. What do I say to that? I mean, I don't want to do an ADR. I made it clear I was no interest in doing an ADR, no interest in agreeing to this settlement and release contract that they sent through. I wanted to stop this. So we continued on.
Sir,
As I said, it was,
I have a question, though.
yes, sir.
In the last email, you had mentioned an alternate, revising your complaint.
Yeah.
Did that come up again?
No, it didn't make sense. I told them no. That's the thing. When I spoke to Paul, and I said, absolutely no way, we need to go ahead with this. Okay. Even at that point, I felt like there was no urgency on their behalf in getting this stopped. And at this point, the sub was already down at the harbour and going through trials in international waters with a vehicle that's not classed. So, and that, sorry.
And where were those tests occurring?
Everett. In Everett, in Seattle, Washington.
And when you say international waters, do you mean offshore?
No, sorry, they were done in US territorial waters. Correction. I do apologise for that.
Okay, yes, sir.
Yeah. So the alternate dispute resolution, this is from the US Department of Labour, just to explain to people what it is. The term alternate dispute resolution, ADR, means any procedure agreed to by the parties of a dispute in which they use the services of a neutral party to assist them in reaching agreement and avoiding litigation. Types of ADR include arbitration, mediation, negotiated rulemaking, neutral fact-finding, and mini-trials. With the exception of binding arbitration, the goal of ADR is to provide a forum for the parties to work toward a voluntary, consensual agreement as opposed to having a judge or other authority decide the case. I wanted OSHA. OSHA were taking me seriously. I was under their protection. If I'd went down the route of anything else, I don't know what would have happened legally to myself and my family.
Sir, were you having conversations with your OSHA caseworker? Or
Yes,
was it all by
I was
email?
talking to him on the phone. Yes, yes,
Were they encouraging you to go the ADR route?
yes.
And you said that you
No.
would proceed on without that?
Absolutely. I had no interest in doing an ADR.
Was your attorney involved in those conversations?
So at the time, I've had 3 sets of attorneys dealing with the Ocean Gate lawsuits. So all in, the first one, the first attorney, he decided to pass this on to somebody else because it was getting so serious. But even then, he said to me, we've got a good case here. And he agreed with me, that initial attorney, we need to stop this. I don't think I'm more vocal in stating my displeasure at this vehicle, potentially, you know, a matter of weeks down the line from my dismissal, paying past. That's what, as you've seen, they were very push, trying to get this out the door as quickly as possible so they could start making profit.
Okay, sir, please proceed.
Okay. Okay, so it goes on. Okay, July the 9th. And I have had several conversations with my caseworker in between this. At this point, it was a day my wife and I were going home for my father-in-law's funeral, and answered the door, and I was served papers from Ocean Gate's attorneys. A lawsuit had been served against myself and my wife. So straight on to OSHA. Good afternoon, Paul. I've attached scans of the court summons Ocean Gate have had served on me and my wife, Carol. My attorney feels it would be prudent to send you a copy. Ocean Gate's further retaliation after raising concerns about health and safety issues leading to my unlawful dismissal have reached a head. And no matter what suggestions my attorney made to settle the matter early, he has been met with resistance and further demands. Their accusations are unjust, untrue, and once again, their threatening behaviour is upsetting to my family, especially, I stated we both lost our dads in a matter of months. So yeah, he was aware of this. His reply, July the 10th, and this just shows you how slow things were moving. And as I said, I was under whistleblower protection, start of February. This is July the 10th. My condolences to you and your wife. I will investigate your complaint as quickly as I can. Please note that at this time, I have 11 cases that are older than yours. I will be in contact with you as needed. Thank you for your patience. So at this point, I'm paying for attorneys. I've got Ocean Gate suing me, and I've got OSHA. I've got 11 cases ahead of them. I spoke to Paul on the phone, and obviously my displeasure at where we were at. We discussed the whole whistleblower protection scheme, how I'm meant to be protected. I asked about OSHA's lawyers again and again. You know, what can you do for me? I was told initially that they would provide legal representation in the event of any form of retaliation, which it also states under the SPA, Seamen's Protection Act. It never happened. So it was all on me. So went on and on. I'm being sued at this point, and we decided to change attorneys. We had to go with a bigger firm, and that was in July 25th after OSHA stated that they've got 11 cases ahead of us. And then at that point, with our new attorney, we decided the right thing to do. Since OSHA were dragging their heels and doing nothing, we decided to countersue Ocean Gate. But rather than what Ocean Gate did is they decided to sue us in civil court, which remains behind closed doors. And we decided to do it in federal court so that it would become public knowledge and the public have complete information from the get-go of that case. So we countersued them on August 15th, 2018. OSHA throughout were notified of everything. I constantly updated them on everything that was happening legally with OceanGate, their behaviour towards us, threatening.
Mr. Lockridge, when you
Yes.
talked to OSHA,
Yeah.
were you talking to their legal before you did that
No,
action?
they
or your
never,
casework?
they never once did I speak to OSHA legal. I had a caseworker that I had to go through. On some of the emails, you see that it also was passed on to so this Paul McDevitt, my caseworker, he had a supervisor. Even when I spoke to him on the phone, he said, I'll resort to my supervisor. And then there was the other individual, was Tobias Kramer. I think he was the assistant regional something for OSHA. So they all knew what was happening.
But you never had email contact with an attorney either?
With
OSHA?
OSHA's attorneys, no.
Okay,
No.
thank you.
No. Okay, so August 2018, 8 months after my termination from OSHA. Okay, oh, here we go. August 29th. Good morning, Paul. Just a quick mail to see what, if any, progress has been made in my claim. You mentioned several months ago about sending a second letter to OceanGate highlighting a second act of retaliation by them against me. I understand the manufacturer of the insufficient viewport that is installed in the submersible Titan is extremely concerned. As previously mentioned, the viewport was designed in-house at OceanGate, and the manufacturer would only build and certify their design to 1,000 metres. OceanGate plan on taking the submersible to 4,000 metres with passengers who are unaware of this. The viewport manufacturer expressed his concerns and said he could design and build a viewport to the desired depth of 4,000 metres, but OceanGate refused. Over and above this issue, which was highlighted at my unlawful termination, there is still the issue of all the other safety points that are critical to paying public and OceanGate's crew safety. So even 8 months after, I'm still reiterating to OSHA, and have it in email, that this is serious. His reply on August 29th. David, I have not started actively investigating your complaint. I still have several other older complaints that I'm trying to finish up. I will get started on yours in the near future. When I do, I will be in touch. Now, I don't need to spell it out, how upsetting off my family and being good, the organisation that can actually step up and do something to stop this, to actively carry out an investigation that could go down to the facility, which I suggested several times to them. OSHA that I was dealing with were based in Seattle. OceanGate were based in Seattle. They were just up the road. Not once during all of this did they actually go down, pay a visit, talk to them, nothing. And the fact that I was told that a second act of retaliation against myself would be, that would also, how would I say, OSHA would step up and basically raise these concerns with OceanGate, and it wouldn't be good for OceanGate. Never happened. Never happened.
Mr. Lockridge?
Yes, sir.
During that back and forth, or
Yeah.
the several months, did you ever get an update on the Coast Guard?
No, not at all. The only thing that anytime I mentioned the Coast Guard, because they'd made that initial correspondence, my caseworker said to me that we will deal with that on your behalf. They will pass all the information on to the Coast Guard. Now, I don't know how it works in terms of that, understanding between the two agencies. I don't know. I don't know whether they submitted all the documents to the Coast Guard initially when it was approved that I was under the Whistleblower Protection Scheme. I truly don't know. Or whether it was just a quick email to say we are currently investigating something that relates to a seaman. I don't know. I don't know.
As your frustration built during this process,
Yes.
was there a reason that you didn't reach out to the Coast Guard directly or another agency, or was it because of the lawsuits?
Yeah, so I mean, jumping back onto one of the emails, and I correspond with OSHA. Hope you don't mind me just jumping back. Yeah, it was the email from Sunday, April 22nd. So this is, this was the one where I said it was a stressful time for my wife and I over the last 5 weeks since receiving the threatening 41-page letter from OceanGate's attorneys. So, okay, I'm just trying to see when it goes in. Okay, because of the immigration implications. As I said, I'm an immigrant in America. I'm not a citizen, I'm a permanent resident. This is in my email to OSHA. After looking online at the Justice Department to see if they could intervene, I found the following paragraphs. I wondered if you could speak to your OSHA attorneys to see what their thoughts are on me involving them at this stage and if it would be beneficial at all. So there was a reply on that. Here we go. The reply was on April 23rd. I just hadn't highlighted it. OSHA and the US Department of Labour do not enforce the Immigration and Nationality Act, and we cannot provide you legal advice. I would talk to your attorney to see what he thinks is the best strategy moving forward. So.
Understand. And sir, I'd like to just touch on if you had a relationship with the local Coast Guard at all ahead of all these events in Seattle.
The only, as I said, the only interaction was, it was to do with, anytime we were doing operations in Puget Sound, not necessarily, Everett Marina doing the dunks, the test dunks, but anytime we were going out, and it was just to give them the heads up that we were heading out. That was basically it. I know, and remembering back to it now, Stockton's disapproval at me doing that, but it's important you let the authorities know that you're about to actually do a dive, and the port authorities for incoming shipping. So, yeah.
Thank you, sir.
No
Please
problem.
proceed.
No worries. Okay. Okay, between August and November 2018, obviously this is information between my old attorney, we do not employ them anymore, and OceanGate's previous attorney. We were served discovery, they were served discovery. There was a lot of documentation going backwards and forwards. That's all in legal. I have none of that here, but I can provide it if you need it. So lots of phone calls, seeing where they were at. They didn't do anything to help us. My confidence was gone in, can I loosely say, the authorities, because OSHA are the ones that are meant to, OSHA were dealing with this. They were my point of contact and did nothing. Okay, so jumping on November to November now, just shows you how long this went on. And as you can imagine, a lawsuit is no easy thing, especially when you're being threatened with fraud. So anyway, my attorney and their attorney, they agreed. My wife and I had decided this is, I'm not going to say pointless, but it was going nowhere, and it was causing more hurt for us, and obviously financially, and it's difficult. So Carol and I decided to walk away from it all, and so we decided to walk away from the lawsuits and informed OSHA this, as they hadn't started working on my case, and genuinely it was too much for us as a family. It really was. So November 24th, OSHA sent a settlement and release agreement between myself and OceanGate, and it literally was a walk away, which I've got here. It was a walk away. There was no financials. I never paid a penny to OceanGate. I would state that clearly. I gave them nothing. They gave me nothing. I stated that I'm dropping the OSHA case. OSHA weren't doing anything. I decided I wasn't going to put myself or my family through any more of this. So we decided to walk away. OceanGate were happy with that. They obviously had a lot more money in the bank than we did. So at that point in November, we signed a declaration with OceanGate and settlement and release with OceanGate and with OSHA. OSHA get a signed addendum back from OceanGate. So we Scarlett and I signed this in November 28th, 2018. OSHA get their, OSHA had to chase up OceanGate's attorney to get the signed copy from Stockton to say that he was happy with it all. And they received that on December the 12th. On December the 13th, 10 months and a week after I was placed under the Whistleblower Protection Scheme, OSHA confirmed the case is now closed, and on the documents which you've got a copy of, the US Coast Guard is informed of such. So correspondence from OSHA. I hope you have no objections to me reading this out. You do have a copy of it. December the 13th, this is addressed to OceanGate Incorporated and myself from OSHA, US Department of Labour, and this is from Tobias, who is their Assistant Regional Administrator. The people that are cited on this are OceanGate's attorney at the time and the United States Coast Guard. December 13th. Dear Mr. Lockridge, this is to advise you that pursuant to a settlement agreement reached between the parties, our agency is closing the investigation of the above referenced whistleblower complaint. OSHA's authority over this agreement is limited to the statutes it enforces. Therefore, OSHA approves only the terms of this agreement pertaining to the Seamen's Protection Act. Having reviewed the settlement agreement, I find it to be fair, adequate, and reasonable. The settlement agreement satisfies the core elements in accordance with OSHA's policy, and it is reasonable in light of the merits of the case. OSHA considers the matter closed and will take no further action. The settlement agreement constitutes findings in a preliminary order under SPA, Seamen's Protection Act, and complainants' and respondents' approvals of the agreement constitute failures to object to the findings and the preliminary order under the Act. Therefore, the settlement is an order enforceable in an appropriate United States District Court under the Seamen's Protection Act. Please note that if OSHA's practice to not disclose the terms of the settlement except pursuant to FOIA process, I'm not sure what that is. And then
For the record, that's the U.S. Freedom of Information Act requirements.
Thank you, which hopefully everybody has now. So yeah, so that was my final correspondence with OSHA, and that was December the 13th. Yeah.
Sir, just to clarify, did you use the ADR process to come to that settlement, or was it outside that?
No, it was outside that.
Were you given any instructions about limitations on what you could do after that settlement?
Absolutely. Get the right one. Okay, I had to sign a declaration, basically talking about the quality inspection report. I'll go on to the settlement and release. Mutual waiver and release of liability, retraction of OSHA claim, and claims arising from non-compete agreement. In exchange for the promises and commitments set forth in this agreement, Lockridge, OceanGate, and OceanGate's owners, investors, attorneys, agents, employees, affiliates, and subsidiaries hereby forever waive and release all claims they have or may have against one another, whether known or unknown, asserted or unasserted, except those obligations arising out of this agreement. I'll jump in, there's stuff in there. It's not that it's not irrelevant. Lockridge specifically agrees to withdraw the OSHA claim and not support it in any further hearing or proceeding, and will not voluntarily testify in support of his OSHA claim or any other or future OSHA claim against OceanGate. OceanGate hereby releases Lockridge from the non-compete agreement appearing in David Lockridge's employee intellectual property agreement, and all claims arising from said non-compete agreement or breaches of the same and are hereby released. The rest and remainder of David Lockridge's employee intellectual property agreement shall remain in full force and effect following the execution of this agreement. Time limitations set forth in the intellectual property agreement, e.g. the non-raiding agreement, by its terms is binding on Lockridge for 12 months following the end of his employment. OceanGate covets and agrees it has not contacted Vulcan Maritime or any representative thereof or any representative of MY Octopus or any of Paul Allen Company regarding any non-disclosure agreements between David Lockridge and Vulcan. OceanGate covets and agrees that it will not in the future contact Vulcan Maritime or any representative thereof and or any representative of MY Octopus or any of Paul Allen Company regarding any non-disclosure agreements between David Lockridge and Vulcan. It covets and agrees that it has not contacted nor will contact US immigration authorities with any information related to Lockridge visa applications. Nor will OceanGate contact any potential creditors of Lockridge, including ex-spouses or previous employers, with information on his current and past earnings and financial status. OceanGate specifically agrees that it will not make any statements or take any other actions accusing David Lockridge of theft of OceanGate property. Each party agrees and covets to the other that he or it will not make any statements or take any other actions to disparage, defame, or compromise the reputation of the other party in any forum. Lockridge covenant and agree that neither has disclosed and will not information about OceanGate, whether or not such information is confidential in nature or a trade secret to any third party unless legally required to do so, e.g., pursuant to a lawful subpoena, save only that Lockridge may disclose the dates of employment and his position at OceanGate to potential employers only. Lockridge represent, warrant, and covenant that neither of them has any copies, whether in paper, electronic, or other form, of any confidential information of OceanGate, including without limitation any copies of David Lockridge's Cyclops 2 Quality Inspection Report, dated January 18, 2018, or any drafts thereof, save only the redacted copy provided by OceanGate to OSHA in its responsive letter dated March 15, 2018, and the documentary information disclosed by OceanGate in the litigation pursuant to the laydown rules of the Rules of Civil Procedure, documentary laydown. Lockridge covenant that within 3 days of dismissal of this litigation, they will destroy and instruct their counsel to destroy all copies of the documentary laydown by OceanGate. David Lockridge covets that the declaration attached hereto and dated November 9, 2018, constitutes, to the best of his memory, the entirety of his communications from and after January 1, 2017, with persons relating to the safety issues concerning Cyclops 2, Titan, and the technology upon which it's based, accepting only communications with officers and employees of OceanGate and privileged communications with attorneys for the purpose of resolving this matter. David Lockridge specifically covets that other than the communications listed in the attached declaration, he never instigated or had any involvement with the communications questioning OceanGate's testing policies and procedures for Cyclops 2 Titan, or the business plans of OceanGate. The parties agree that damages in the event of a breach of this obligation or representation in paragraph 3 and 4 of this agreement are difficult to estimate and would be difficult to prove. As liquidated damages and not as a penalty, therefore, the parties agree that any violation of paragraphs 3 or 4 hereof shall result in an award of liquidated damages in the amount of $10,000 per occurrence.
Sir, I'd like to just
Sure.
stop you there for
It's quite a
minute.
document.
After signing that,
Yeah.
was it your understanding that you could not approach the Coast Guard or another agency with safety concerns about the Cyclops 2 or Titan?
Yeah, pretty much. Yeah,
Unless you were subpoenaed to
Yeah.
provide information?
yeah. That's why gladly, if people want to know anything, subpoena me.
There were several companies mentioned. I think I heard Vulcan.
Yeah.
What were the basis of the other companies? Are they relevant?
They were other submersible companies that I'd worked for. Yeah, it was.
Thank you.
They were just intimidating.
Sir, can you talk about what happened? Or can you talk about any involvement you had monitoring or with OceanGate after that settlement?
There was nothing. There was no correspondence with OceanGate whatsoever. Is that what you mean, sir?
Did you ever have any communications with employees of OceanGate after that?
Yes, I did. The contractors, Tim Countersuit and Chris Imes, both subcontractors for the company OceanGate, no staff employees. I never spoke to any staff employees at all.
How long did you stay in communication with the contractors?
I'm still in communication with Chris Imes and Tim Countersuit, who I've known for years. We did, even within the last few years. We never went into depth. Tim, because of the threat of the $10,000 per occurrence, very reluctant to speak about it. And I know Tim was still working with the organisation. So he knew there was a safety report. And I truly believe what Tim said yesterday, he's probably never seen it. And I hope seeing what he saw up today, he will understand why I followed the path that I did. But in terms of communication, yes, the two contractors, nobody else.
Were you in contact with those contractors during the Titan operations during the summers of 21, 22, and 2023?
So I met with Tim's sister, lived close to us. We met, we never even discussed we basically never discussed OceanGate. So we do have a lot of mutual acquaintances it's a very small industry. So I'm sure Tim will come up, take the stand on that as well. But no, we didn't. He knew I was displeased and something happened, but yeah.
Were you aware of the second hull doing operations off of Canada?
Yeah.
I mean, for all three of those sessions or years, from 21, 22, and 23?
Oh, absolutely. I mean, OceanGate were, as everybody knows, they like to promote themselves on social media, so we could see it, and I'm not going to lie, myself and my family, every year that they would go out, it was like, is something going to happen this year? Like, I mean, the way the company were going with this project and bypassing all the standardized rules and regulations that are set in place by people with experience, years and years of experience, from the US military to the Coast Guard, the classification agencies, even manufacturers of some of the equipment, they bypassed it all. It was inevitable something was going to happen, and it was just when.
Sir, I just have a couple follow-up questions from your earlier testimony, if we can kind of go back a bit. Thinking about the mission on Cyclops 1 to the Andrea Doria, did you produce an incident report after that occurred?
Yes, I did.
Do you know if there was a notice of marine casualty made to the Coast Guard?
No. No.
Do you know if the Coast Guard was aware of those operations? I think you said they were alerted.
Yeah, from Boston. Yeah, I mean, before we got involved with the project, what I did at the start of every mission objective that we had, I would, as part of my my list of outside help and who to notify. I mean, I brought one today from, it's somewhere in here, and it was an example of when we were doing the dives on Alcatraz, who the named individuals that I had as point of contacts with Coast Guard, port authorities, the diving companies, the ROV companies. So no, every trip, I would formulate that. It was part of the pack, which was kept topside, and another copy was kept back at Everett, and which had all the phone numbers to call in the event of any incidents, accidents. Yeah, all that was,
And in those communications with the Coast Guard,
yeah.
how were the operations characterized? And I mean, from a standpoint of like carrying passengers, scientific operations, do you know?
Sure. Passengers? Yeah. Yeah.
Did the Coast Guard ever inquire about the vessel being used, or?
No, there was no in-depth conversations about the vehicle. I was never asked if the vehicles, even Antipodes, if the vehicles were classed. There was no, I don't know. I'm not sure whether it was, I don't know. As I said, submersible industry is very small, and how many subs have been towed out from Boston Harbor, you know? So, I mean, the overall experience of the people that we were dealing with, I may be speaking for them, you know, necessarily, but it may have been very limited. So I would make them aware that we were going to be carrying out operations. I'd give them the lat and long of where we're going to be going. I would let them know this is the planned departure time from port and return back at this date.
And when you say operations, just to
Yes.
clarify,
Yes.
you did say with passengers, not like
Absolutely.
scientific.
Yeah, no. If it, I think you've got OceanGate's scientific officer coming along. There was never really any science with OceanGate. They had no sampling equipment. It was all go down, look, take video. That was it. If any scientists went inside, they were basically looking through the viewport. They could take their own notes. There was no, you know, I'm not speaking for the new Titan. I don't know if it had a CTD, you know, or any sort of Niskins. I know there was talk the other day of Niskin samples.
It did have a bottle?
It did have a bottle. So when I was there, we never had any of that. No sampling devices at all.
Did you provide any research? You mentioned the 3D modeling
Yeah.
of the wreck. That could potentially be considered scientific operations. Did you provide data to any non-organizations, anything
No.
along those lines?
The time when we actually had that 3D sonar, which was on loan at the time, to create this 3D model, as I've said, because obviously what happened with Stockton damaging the landing skids on the sub, plus obviously incremental weather, there was one dive in the Andrea Doria, so the stuff you would see on social media was from that one dive. That was it. Not sufficient enough to create a 3D model with the purpose of what we set out to do.
Understand.
Yeah.
Sure. During that dive on the Cyclops 1,
Yeah.
was the submersible fully classed during that dive?
No, Cyclops 1 has never been fully classed. Cyclops 1 only had, and I remember seeing the document that Stockton produced. I remember him talking about it before they did the Flower Gardens dive to 500 meters, but I remember seeing at one point before we even went out there, this report or letter stating that, as I said, somebody will need to go through all OceanGate's files and folders, but from memory it was DNV, and it was a letter from one of the classing individuals there stating that the hull would be classed, the viewports, and the upper hatch. That was it.
Did that bother you about conducting operations on an unclassed submersible?
a fully unclassed submersible. I had confidence at the time with the involvement of APL that the control systems, I mean, I know the life support system, like the cylinders were all thoroughly inspected, the gauges were calibrated, the scrubber that we had in there at the time was an approved scrubber, you know, things like that. I was happy with the systems and I felt confident in my experience that I could take paying passengers down safely. Yes.
Thank you. And sir, earlier in your testimony, you referenced Coast Guard navigation and vessel inspection circular 593.
Yes.
I'd like to call that exhibit up, please, Lieutenant Steele. And just to clarify, sir,
Yes.
during those operations, were you aware of this NAVIC at the time?
So I was aware of, so as part of that NAVIC, there was a manual that actually came out as part of it. I think it was safety for, quote me, safety for passenger submersibles. There is a book, I do actually have a copy at home, which I'd had for years, and I actually had it prior to Ocean Gate. So there was a lot of correspondence from that. I was aware of that. In terms of the guidance, I knew there was, I'm not going to say it was loose, but from my understanding of the document, there was this, any more than 6 persons had to be inspected, and any less than 6, it could be uninspected. Sorry.
Yes, sir. And so that was clear to you from the NAVIC, that
Yeah.
information?
Yeah, yeah.
And Mr. Lockridge, for the record, is referring to subject 3, if you could scroll down, please, Lieutenant Steele, to B and C. As indicated in the NAVIC, it states, this is Coast Guard guidance. This is not a regulation, just for
Yes.
the record. But it does state in section B that any submersible carrying 6, I'm summarizing, 6 or more passengers needs to be certified and inspected under subchapter T. And then in section C, it talks about submersibles carrying less than 6 passengers and that they could serve as uninspected vessels. Is that consistent with your understanding, sir?
Yes.
I want to make a note for the record, and also call up, when you get a chance, Lieutenant Steele, 46 CFR Part 175. And just as we pull up that's just a federal regulation. I don't have it submitted as an exhibit, but I want to point out for the record that 46 subchapter Part 175 was updated in 1996 to clarify that any submersible carrying 1 or more passengers has to be inspected by the U.S. Coast Guard. However, that NAVIC was still in effect at that time.
Yes.
Were you aware of that regulatory change, sir?
The change, no, I was not. No.
At this time, I'd like to pass the questioning to the NTSB. Mr. Muse?
Thanks, Mr. Neubauer. I have a few follow-ups, and I apologize for bouncing around a little bit,
Yep.
going back to this morning. So, and we just talked about Cyclops a little bit. Which class society was it classed under before Ocean Gate?
I can't honestly say, but it was classed. I really don't know, but it was definitely a classed vehicle beforehand.
So after that,
Yes.
what was Cyclops missing that would preclude it from getting classed?
So the issue with Cyclops, because what happened was when they purchased the vehicle, they ripped it all apart. So the hull was all one piece. The control system, I wasn't actually there when that happened. It was years before. And I think this is where the involvement of APL at the time, they came in and obviously helped out with Ocean Gate to modify that submersible. Now, to keep a sub in class, you have to annually do a certain set amount of tasks with the surveyor witness to basically sign off. Now, that sub had been out of commission. I don't know for how many years. I'm sure that information will be readily available. I do not know at this time. But they did so many modifications to it, it would have to, excuse me, it would have to fully go to a panel to get them to sign off and everything, but that was not the intent of OceanGate. Cyclops 1 was going to be used as a test bed to actively trial new equipment. So it was constantly going to be evolving and changing. That involves cost, and I know Stockton was very aware of the cost implications to do that. So hence why he decided to go down the route and get the hull and the acrylic signed off.
These class surveys, in addition to the material condition of the sub, do they get into operations such as training, communications, navigation, those kind of things?
Some of the agencies do. I mean, when they come along, we have everything out in front of us. In terms of, I know more recently, over recent years, not last year, but recent years, the surveyors will come out. We have to have everything from, we basically do all the battery maintenance. We have to, you know, they've got access to everything from that we do to the sub in terms of any maintenance on batteries, the hull, any of the components. And they have dive plans, they have access to everything that's in there, who the crew were. So they have access to all of that. I have seen in the past where the agencies will come along and ask to see the dive records of the individuals that are actually diving the subs. And you've got to physically show them a log, or if you're actually using something that's on a system where you can actually key in the information, everything is all on an electronic database that these surveyors can actually look at. So they have full access to that at any time.
And these are class surveyors, not,
Yeah,
how about national regulatory agencies like the Coast Guard or MCA?
Negative, no. As I said, on any of the submersibles I've worked on, no Coast Guard have came along and actually inspected the vehicles themselves.
The pilot training manual that we saw earlier,
Yeah.
was that a class requirement? Or is there a standard that it has
It's
to
a
meet?
standard. You have to have the manual that you showed was pilot training manual, which basically encompassed all the knowledge to be able to get somebody trained up as a pilot. The manual you showed did not show the operations manual. That's another thing that the class and agencies do look at, yeah.
Okay, I know the American Navic gets into a little bit of pilot training. Is there other nations that require that kind of training?
And pilot training,
Yes, sir.
there's, I mean, in terms of
Such
submarine
as
rescue,
an MCA endorsement or nothing
no,
like that?
No. I know 2 years ago, the Australian authorities, what they were looking for, this was 2 years ago when I was down in Australia, and they decided to change their regulations. Now, AMSA, which is the Australian Maritime Safety Committee, what they decided to do was they decided that anybody operating, especially one of the vehicles that I'm trained and in date to pilot LR5, which is a submarine rescue vehicle down in Australia, that we had to do like a seaman's course, like a bosun's course, to actually show that we can do navigation. So yeah, the company, James Fisher Defence, paid for everybody to do that. But they are the only nation that I know of that insist on that.
Earlier, you talked about each manufacturer having its own training or licensing program.
Correct.
So given the circumstances of this accident,
Yeah.
Do you think it's such a requirement by nations would be beneficial, or is it needed?
Proper training.
Yes, sir.
Absolutely. Oh, it's imperative. You can't. I know Stockton's vision was, give somebody these PlayStation controller and, within an hour they're going to be a pilot. It's like showing somebody how to fly a helicopter and then putting them in charge of taking passengers up or doing work with it. It's so important, training, and it's not overnight. I mean, as I said, for myself as a submarine rescue pilot, it's very in depth. It's going above and beyond just doing a standard passenger submersible. With this, we are doing dry transfer. We are locking on to a submarine at depth and recovering people, which we do on an annual basis with all the systems, all the nations do. And, for one of the organizations that I work for, with the experience that myself and my colleagues have gained in that industry over the past 23 years, one of the companies I work for, Mansub International, we've developed this training program for foreign military to employ our services, and we will go out and take submariners and train them up, and it's a rigorous training program, and we will give them the basis to safely pilot that submersible. We will give them all the training material and all their years of experience. And it's not something that happens overnight. It's a long process for us to deem those individuals capable and competent enough to be able to do the task at hand of going down, mating with a submarine, military submarine at depth, and doing hatch openings. It's quite a procedure.
So that's happening now.
Oh,
So
absolutely.
is there a need for a regulation or an IMO requirement to have that training, or is it industry doing an adequate job as it is?
I feel just now Triton do their own house submersible pilot training program. U-Boat Works, another manufacturer, they do training courses in Curacao. I think it's like a 3-week training course. Their courses are a lot shorter than what myself and a lot of my colleagues did. I mean, with us, it took years to get up to a competency level where we could safely land on a military sub. So I have never sat down and reviewed any of these manufacturers' training manuals to say, oh, I think that's sufficient or not sufficient.
Okay. Regarding contingency plans, we talked a little bit about Andrew Doria, but not specific to that case. The ROVs and the divers that you have listed in your plan,
Yes,
are they actually informed about what's going on? Or is it
Absolutely.
just
100%.
it's not just a list of phone numbers that you have?
No, not at all. So anytime we formulate it, basically it's a dive plan before you actually leave the shop. And we would let them know exactly what we're going to be doing. So if there was an issue, we would discuss the area, whether it would be a wreck or an area of interest that we wanted to go to. We would show them the lay of the land, the obvious hazards that are marked on nautical charts. We would do all of that, all of
Okay.
it. Yeah.
Is that a class requirement, or is that an industry
Negative. It's
standard?
not
Is
a
that
class, not a class requirement. No,
okay? Is that just your practice to do that?
absolutely.
Is it an industry-wide practice to do that?
Yeah, I mean, excuse me. In terms of the organizations I work with just now, most of the companies have got a second asset on site, whether it be an ROV or whether it be another manned submersible. So we have our own self-help plans so that we know what to do. We regularly do training so that we can do emergency recoveries. We do recoveries with ROVs, with the other sub. We do training all the time to run through drills, procedures. We do a lot. We do a lot.
Was any of that required by Coast Guard Sector Boston?
Not that I know of, no.
Did Boston require anything for?
No.
I believe Andrea Doria is actually in Woods Hole's area of responsibility. Did you remember talking to them?
We were going out from, the only individuals that we spoke to at Woods Hole was the Alvin team. So they were another point of contact for us to actually resort to. They have vessels at, what's the name of the area? So they were aware of what we were doing. We actually, at the time, we paid them a visit as well, got a tour of the facility. That was prior to carrying out the operation on the Doria. So they were aware of what we were doing, but the US Coast Guard in Boston, they were the ones that we informed that we were going out from Boston Harbour, returning to Boston Harbour.
But not the Coast Guard in Woods Hole?
Negative. No.
Okay. I'll fast forward a little bit to your report again.
Yep.
It looks to me something similar to a shipyard punch list.
Yep.
A little bit.
Yep.
So before that, did you or your crew have a chance to witness the electrical checks and mechanical checks of each component as they're getting installed in this new submarine? Yes.
No.
As systems are coming together, do you get to witness the commissioning of those systems, like the life support and the ballast?
No, and you will, so in terms of the life support, the only integration I had with Stockton at that time was to go into the sub and test his scrubber for him. That was the scrubber that we showed up on the slide, the homemade one. I never actively was involved. I can't speak for the contractors that worked for me at the time, but no, I wasn't involved in the construction. It was all in the hands of the engineering team. The submersible itself, the percentage of it was done in the engineering side of the workshop. I wasn't allowed to go into, and I was told several times. And then the vehicle itself, as it was coming to fruition and almost complete build, it got moved into the operations area.
Was this your first new construction submersible project?
From scratch? Yeah, because, well, as an involvement as in the position I was in, I've been involved in new projects before, submersibles that I've never seen the water, you know, from proof of concept. I've been involved in that, but in operations.
Is it
Yeah.
normal for operations to comment on the commissioning procedures as?
Absolutely.
How about the sea trial procedure, what I call sea trial procedures?
Absolutely, 100%.
That didn't happen at?
No.
Okay. I believe that's all I have. Thank you, Kevin.
Thank you, sir. Just to follow up on that, were you with Ocean Gate when they started sea trials for the
No,
Titan submersible?
I was let go beforehand. From memory, I think they went out March. I think March was when they first put the submersible in the water, and that was in Puget Sound. So, and the legal correspondence, the Ocean Gate's attorneys at the time, I stated this to OSHA, and the Ocean Gate's attorneys at the time went back to OSHA and said, we will not be operating this vehicle in US territorial waters. They did. And I several times said to my caseworker, they're diving this, go down. It's on social media, they're down there all this week. And nothing happened.
Was it your understanding they meant commercial operations or testing operations or any?
Testing.
Okay.
Yeah.
Was that made clear, that it was testing operations?
When I say made clear, this is everything I was reading on social media that Ocean Gate were putting all over the internet, showing that they were actually diving down there. I can't state who the crews were or pilots.
Okay, thank you, sir, for that clarification. So this is potentially testing the submersible in US
Potentially,
waters?
Yes, yeah.
One thing I forgot to ask you,
Yes.
so were you involved in the registration or flagging of process or verification for any of the submersibles you operated on?
Me personally,
Yes, sir.
no. I mean, I may be speaking out of turn, but I think a lot of that was to deal with the naval architects and the project managers. They would deal with that. Yeah.
Were you aware of whether the Antipodes or Cyclops was registered or flagged?
They were. Right now, I can't remember, truthfully. Yep.
Do you remember a discussion ever coming up about the Titan's registration or flagging?
I said I was kept out of everything after the Doria. They kept me away from the entire project.
Okay.
Yeah.
Thank you, sir.
No problem.
Are you okay to keep going? We have one
Oh,
other,
gotcha.
or would you like
Yeah.
to take a break?
Absolutely.
Okay, sir, at this time, I'd like to pass the questioning over to Mr. Fawcett.
Thank you, Mr. Lockridge. My name is Keith Fawcett. I'm a Coast Guard Marine Casualty Investigator. Thank you for being here.
Thank you.
So I would like to also clear up a few things from your testimony. So we've heard discussion that originally the titanium used for the domes and rings were going to be grade 5. They later were, they used grade 3 titanium.
Yes.
Did that cause you any concern?
I didn't even know. I had no indication whatsoever that they were changing the titanium. I was all out with my remit with the company.
So 3 times, to my knowledge, in this testimony, Mrs. Wendy Rush has been, her name has come up. Her role within Ocean Gate or any of its subsidiaries while you were working with that company?
So from memory, she was leading the Ocean Gate Foundation. And I'm not sure at the time when Wendy actively took over as the communications director, but Wendy was in the shop a lot. She was at the facility quite a bit.
Was the foundation co-located with where the company was located, or was it in a separate location?
That I'm not sure. I don't know whether they worked remotely at our facility. I'm not sure where the company address was for the foundation.
Yesterday's testimony, they were talking about the foam that was placed between the hull liner, the carbon fiber hull, and the sleeve that fitted into the submersible. Are you aware that foam was used?
See, when I was there, they were using that HDPE. I would need to relate to my notes. It's basically chopping board material. That was in my safety report. You'll see the material. The dangerous fumes. And when I was there, from memory, they were actually using sections of that to basically shim out the inner sleeve from the carbon itself.
Would you typically find that in a manned submersible, the use of that type of material?
Absolutely not. That material, there are plastic materials out there that are fire safe. They're not going to emit enough fumes. That material, they genuinely purchased that from Home Depot. It was the worst grade of, I'm no expert in HDPE, but it was appalling. That is what they use, the cheapest plastic. And the same on the inside of the sub as well. And I can't speak for Titan that went back out. They were putting 3M carbon fiber tape over control panels to make it look, I don't know what they were trying to achieve. Anyway, that material, I took that outside and did a flame test with that. I'm not saying it was 3M, but it was a self-adhesive carbon-looking tape. It could have been from anywhere. And you'll hear in the voice recording, I mentioned that as well. The fumes that were emitted from that it was a lot. It was dangerous, put it that way. So yeah, so I was under the assumption that they'd actually used this HDPE and were using rods at the side in between the inner sleeve and the carbon hull itself to space it.
And you mentioned that oxygen was admitted into the hull during diving operations?
The oxygen was actually, well, that's the thing. I did no diving operations with that submersible, but when I was there, we had internal batteries kept under the floor, and we had the high pressure oxygen tanks under the floor as well. Now, it's in some submersibles, even the class submersibles, some of them, you can have the O2 cylinders inside. There's nothing wrong with that. They had basically stored this, the cylinders in the bilge next to the batteries, and I mean the batteries weren't covered over. The cabling that they used was not like a fire retardant material in any of their submersibles. I'm sure Patrick, when he comes up next week, he will discuss the type of material they use in the inside of the subs for build and design. But that material is there, so no fumes are given off in the event of a spark, a low power spark or anything like that. None of that was in there. The batteries were completely exposed, and then they had the cheapest HDPE flooring put down, and they basically bought sheets of this stuff, cut it out, and slotted it in place.
So have you, as a submersible pilot, ever operated an experimental manned submarine?
And do you want to go back to Cyclops? Because it was, even although we had the hull, the viewport done, it, I suppose, was in a way experimental as well because of the amount of modifications and continual progress of the way APL wanted to operate it. I don't know, could we class that as experimental, or I don't know.
Yeah, that was,
Other than that, no, absolutely not.
When you say experimental, do you mean unclassed, uninspected? Or is
yes, a prototype that's not been proven, classed, or inspected as experimental.
No, just Cyclops 1. But the thing is, even when a vehicle is actually going through class and the build's approved and pressure tests are done, when the manufacturers fully build these submersibles and the pressure tests are complete and everybody's happy with it, then you go into manned testing. Now, at that point, during manned testing, there is no final completion sign-off from the classification agencies. So at that point, I'm not going to call that experimental. It's all known and proven products that are going in these vehicles, but there's no full classing of a vehicle until all that testing phase has been complete, from harbour trials to sea trials.
And then would you describe Titan, based on the information that you know, as an experimental manned submersible?
Yeah, but it was an experimental submersible that they had already taken deposits to go to the Titanic in. So, yeah.
And what would be your concerns with carrying passengers who are not intimately familiar with submersible operations on an experimental manned submersible?
Well, as you've seen from all my correspondence and dealing with OSHA, I was very concerned and I didn't agree with it.
So I'm not going to ask Lieutenant Steele to pull it up, but yesterday we did pull up the dive operation risk assessment for the 2023 Titanic expedition. Okay. It listed a set of steps and procedures that would take place before diving operations. Did you have a similar operational risk assessment procedure prior to the Cyclops 1 diving on the Androdoria site?
I can't speak for what was shown yesterday. I was flying at the time, and unfortunately some of the Wi-Fi would drop in and out. I never saw the document that you produced yesterday, but yes, there was a risk assessment carried out prior to every day's diving. And contrary to what Tim was saying yesterday, doing the risk assessments and the toolbox talks the night before, I never did it the night before. You do it the day of. Weather changes, current changes, vessels condition changes. I mean, anytime we are doing operations, we have to get the verification from the captain, from the engineers, to make sure that their support vessel, the launch vehicle itself, there's no issues. If there's any issues with that, with an engine down or high pressure, an HPU down for the hydraulics for operating an A-frame, we will have to do a toolbox on that separately and discuss the risks in doing so. So with regards to OceanGate, absolutely. When I was there, we did toolbox talks and risk assessments on the day of the dives themselves, not the day before.
Turning your attention to the June Androdoria mission,
Yes.
There's a term that has been used in conjunction with that, Argus expeditions. Do you know what that is?
That's the thing, and when we were speaking about it earlier on, I remember the name at the time, but I had no involvement. And I'm not sure. I mean, could you possibly tell me, because I'm not sure what it is. What is Argus Expeditions? Can I ask that question, please?
Could you
Mr.
pull up-
Fawcett,
Yeah.
you shouldn't speculate.
Right, so if you would pull up Coast Guard Exhibit 078, that's the OceanGate April 2016 update newsletter. And while that's being pulled up on the bottom of the page, I have no idea what it is, and that's why
Thanks.
I'm asking.
No worries.
But while the lieutenant's pulling it up, and I will read from it to make it
Okay.
easier.
Yeah.
It says, OceanGate entered into an exclusive contract with Argus Expeditions to conduct submersible expeditions for individual explorers and affinity groups. These expeditions will explore iconic shipwrecks, hypothermal vents, deep-sea canyons, and rare biological events around the world. The first of these expeditions is scheduled to survey the wreck of the Andrea Doria near Nantucket in early June, which 2016.
Yeah.
So I'm just asking if, like, on the vessel you were on,
Yeah.
were any of the personnel, was the vessel, did it relate to Argus
Not that I know
Argus
of.
Expeditions?
No, not that I know of. No. In terms of the having it on their newsletter, I mean, I tended not to read the newsletter. So no, I don't know, and I never had any involvement with, from what I can remember, anybody from Argus Expeditions. I don't even know if it is an actual organization. I'm not sure.
At the bottom of that page, in the
Yeah.
same exhibit, you see what looks like the Lars platform or a similar platform.
Yeah.
With a vessel towing it
Yep.
through the waterway. Does that appear from the voyage you undertook going out to the Nantucket site?
No, that boat's tiny. That's a very small boat. That looks like something that was used in Puget Sound. That's not an ocean-going vessel by the looks of it.
So I want to talk about towing for a minute.
Yeah.
So the Titan was towed on the Lars platform by the Polar Prince.
Yeah.
At one point, they jogged for weather and proceeded a couple of 100 miles away from their intended position, and then eventually went down to the Titanic wreck site, almost 300 miles from St. John, more than 300.
Yeah.
Is it typical to tow on the surface a submersible on a platform for a distance of 300 miles in
No.
your experience?
At all. No. I mean, I know Mr. Carterson was talking about the vehicle itself. Anytime we would take it out, even if we were taking it out in Puget Sound and doing a dive, traveling a couple of miles, if there was even a little bit of chop on the surface, the submersible would be ratchet firm, flat, and stable on the Lars platform. And as Mr. Carterson explained yesterday, it will just move with it. There's no, unless it was really bad weather, which you would not take that platform, in my eye, you would not take it out or tow it out in bad weather, because at that point, if the straps are not securing that vehicle to the deck, it runs a risk of damage. So, but no, it's not normal towing anything like that out 300, 400 miles. No.
And then on the Andrea Doria mission,
Yes.
pardon me, there was a mission specialist, Renata Rojas.
Yes.
Did you tell her that you recommended she not participate in Titan submersible operations?
No. And I will, for the record, since I was made redundant or fired from OceanGate about a week, 10 days before, my attorney at the time's got a copy. I probably still got it. And I got a text message from Renata stating, I need to look for it, but it's along the lines of, what the hell is going on? You have to tell me what's happening. Now, I spoke to my attorney at the time when I got it, and he said, do not. I also got somebody from the media got in touch. This is all within a matter of 2-3 weeks, say, of me being terminated from the company. And somebody from the media getting in touch saying, what's going on? We need information. Same again, my attorney told me, do not talk to them. So I didn't. So no, I've had no communication with Renata, and no, I did not tell her not to dive in the Titan submersible. And considering the Titan submersible nothing had even been fabricated, there was basically nothing. It was nothing. It was still in the design phase when we did the Andrea Doria mission. So no, I would not say that to her.
So I don't have too many more questions, but I do want to ask you, you mentioned medical quals
Yes.
related to the various, you mentioned there was an offshore qual and so forth.
Yeah.
To obtain that qualification, because I want to make sure we're not talking about the ability to provide medical assistance like emergency medical technician.
Yep.
Does this mean that you got a physical from a medical doctor?
Yes.
Which produced results which gave you a particular qualification?
That is correct, yes.
So looking at, while you were working for Ocean Gate and training pilots,
Yep.
qualifying pilots
Yep.
through the training and qualification book,
Yep.
was Mr. Stockton Rush a qualified and certified manned submersible pilot?
According to the company, yes, he was. The individual that trained him, and I'm not 100% sure on the name, Scott Cassell. So you would need to speak to him about what sort of formal training he put Stockton. Not going to speak for Mr. Carter. I don't know whether he was involved in any training of the Cyclops, with the Antipodes, because Tim used to manage and operate that vehicle for years before. So he had a vast amount of experience on that, and I'm not sure whether Stockton or Guillermo, who was one of the other co-founders of the company, and I know he had dived this up, I don't know whether they went any formal training with these gentlemen. I'm honestly not sure.
So in your position, did you maintain the formal training records for submersible pilots that were qualified to operate the company's equipment, such as manned submersibles?
That I did when I was there, yes.
In those files, did you have a qualification or certification letter for Mr. Rush?
No.
Just a few final questions. Did the company require submersible pilots to be chemically tested to make sure they weren't using substances?
No.
And I was going to say substances such as those that impair performance?
No.
Did they have a requirement that people who were going to operate the submersibles undertake a physical to determine if they had physical conditions, which might, since they're going to be deep into the ocean with the care of passengers, but for example, that they weren't epileptic, had a heart condition, had other medical conditions?
So with regards to working for Ocean Gate and working with the other systems, we take passengers in the subs a lot, scientists, media. They